Tomorrow marks exactly 1 year since Richard Allen was sentenced to 130 years in prison for the 2017 killings of teens Abigail Williams and Liberty German. And now Allen is appealing his conviction. His attorneys have filed a sweeping 113-page brief asking the Indiana Court of Appeals to overturn the verdict and order a new trial. The appeal focuses on three key claims. The first one is an unconstitutional search warrant. So the defense says that police obtained the warrant for Allen's home using false statements and omitting witness descriptions that didn't match Allen or the bridge guy. The second argument, solitary confinement and coerced confessions. Basic idea, Allen spent 13 months in pretrial solitary confinement. His attorney says the isolation caused severe psychosis, dramatic weight loss, mental collapse, making his confessions involuntary, unreliable. And the appeal states that Allen was deemed, quote, gravely disabled by prison psychiatrists when he made incriminating statements. And the third one, that Allen was denied the right to present a defense. So the defense claims that the jury never heard evidence about alternative suspects, challenges to the ballistics evidence, or videos showing Allen's deteriorating mental state. So now the case heads to the Indiana Court of Appeals, where judges will decide whether this conviction stands or whether the case returns to court. I want to bring in two people who have been following this story from the beginning. Áine Cain and Kevin Greenlee. They're hosts of the very popular podcast, The Murder Sheet, and the authors of the book, Shadow of the Bridge, The Delphi Murders, and the Dark Side of the American Heartland. Thank you so much for coming on. Kevin, I'll start with you. What did you think was the strongest argument so far in this appeal, and do you think it'll be receptive by the appellate judges?
The thing to remember about an appeal like this is there's a very high bar for the Court of Appeals to actually turn over a previous conviction, because the courts give a lot of deference to the decisions and discretion of the trial court judge in what is allowed or what isn't allowed. And so it's very unusual for them to say this judge did something so wrong that the case needs to be overturned. And frankly, I don't think they met that bar in this appeal.
You don't believe, Kevin, the lack of introducing Odinism as an alternative, the way the bodies were positioned and this kind of cult that, the defense wanted to suggest somebody else must have done this. That religious component was very interesting, but it wasn't a part of the trial, right?
It was not a part of the trial, and the interesting thing is that prior to the trial, there was a 3-day hearing held in which the judge gave the defense attorneys the opportunity to make their case that these people, these members of this cult, actually had anything to do with the crime. And I was at that hearing, and it was very striking. Their investigator admitted under cross-examination by prosecutor Nicholas McClelland that despite all of their work, they were not even able to place some of these Odinists even within Delphi city limits at the time of the crime.
Right. Áine, I want to ask you this. How serious are the claims that police misrepresented witness descriptions, right? That they misrepresented it to the extent in order to get a search warrant? That feels like a egregious violation. If true, you think that's a strong claim?
Yeah, I think if it was true, it would certainly be a strong claim. Is it true? No. I mean, I think it's something we have to understand that appellate attorneys, their job is to come in and to advocate for their client. And they're going to go through if they get the search warrant thrown out, then they lose the gun evidence, which is pretty crucial. So we can understand why they're doing this. But I'll give you an example, Jesse. There's an instance where they're talking about one witness who they claim that she saw a muddy and bloody man. And what they say is, well, the transcript just says muddy. So Tony Liggett, then a detective, now the sheriff of Carroll County, he inserted bloody. So that's interesting. But when you actually are aware of the case, you're aware that that particular witness actually was on the stand at trial talking about how she is adamant that she said muddy and bloody and that she was mumbling and the transcript didn't get it right. So something like that, it's not really just coming from Liggett. So they're kind of doing some things like that where when you know all of the facts, it becomes a little bit less compelling.
And by the way, one of the big things was the statements that he made, right? These incriminating statements, but they're saying his mental state was deteriorating. You can't rely on anything he said. What are your thoughts on that one?
One thing that they mentioned that was interesting is they kind of flag, hey, he made confessions that didn't even meet the facts. He said he shot the girls, so we need to maybe look at that. But what came out at trial was that He's never been recorded saying anything like that. What happened with that seems to be more of a game of telephone where people wrote something down and then reported it later. So there were certain things like that. It sounds compelling at first blush. When you look into it a little deeper, it's, for me, when we're hearing from all of these correctional officers and all these different people who interacted with him in prison, so many of them thought he was malingering. And the reason for that is he would basically be acting a certain way, doing bad behaviors. And then when that person would stop paying attention to him, it would stop. Now, anyone who deals with some kind of psychotic disorder, you can't switch it off. So yeah, I mean, certainly his behavior was concerning and disturbing for sure, but whether or not he's actually psychotic, it doesn't really seem like there's evidence to that.
All right, so you both are not convinced that this has a shot, but Kevin, I'll ask you this timeline real quick, 30 seconds. What happens next? When would a judge decide? When would we see something?
Next thing that happens is the state gets an opportunity to reply to this brief. They're given 30 days. They may ask for an extension. After that, the defense gets a chance to reply to the reply, and then it's up to the judges. They might ask for an oral argument, or they might just make a decision based on the briefs.
You two are a good team. You should do a show together. Just my FYI. I just want to say that. Kevin Greenlee, Áine, Cain, thank you so much for taking the time. Appreciate it.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.